Joining me now is the Minister of Crown-Indigenous Relations, Marc Miller. Minister, good to have you on the program. As you know, Indigenous leaders urge the federal government, do not appeal this decision. Pay the compensation, the $40,000 that these kids were owed. Last Wednesday, the new Minister of Indigenous Services, your partner in this, Patty Hyder, literally said, and I'm quoting her, "I believe it is in no one's interest to continue litigation and that compensation is due." But Minister, litigation is continuing. I understand there's a pause, but the government still appealed. Why?
Well, first, Evan, no one wants to appeal this case. This is something that we did not take lightly, and we haven't appealed part of the decision. That's the reality of it. What we've done is we've said, and I don't like the imagery, is we are putting down our swords. We're not filing motions and oppositional papers. We're sitting down and we're saying, let's hash out an agreement that is global in nature and goes and touches on one thing that is so important to all the parties, which is making sure this model doesn't reproduce itself. It's what the parties have said time and time again, and we're willing to do it with a significant financial package on long-term reform, major capital investments, so that we're repairing the harm that's been caused over decades, but also moving forward to have a system that doesn't prejudice Indigenous children.
Okay, I'm going to press you on that. In the original Human Rights Tribunal decision, the government would be paying billions of dollars to up to 50,000 kids who were impacted by the child welfare system. You're saying that since the federal court, the federal government lost in the federal court, you're saying that you've now since offered everybody involved a financial package that would be more than the billions of dollars that the federal government would already have to pay out to these kids who were involved in this, and that has allowed everybody to take 60 days to try to sort this out?
Yeah, and it won't be an easy 60 days, Evan, and it's more than 50,000 children. It could easily be double that. This is not an insignificant investment, and indeed it's something we need to compensate for the harm that's been caused. No one is shying away from that fact. What we do know is that these are very complex files. There are 3 litigation parties, some of them purporting to represent the same children, looking for proper compensation for children that suffered harm. Again, let me repeat, the CHRT order, if it were implemented word for word tomorrow, would only compensate children up to $40,000 and not proceed to long-term reform. So what we're saying to the parties, and the parties have agreed, is let's pause this, let's sit down, let's spend some time productively in the next 60 days, not opposing each other with lawyers, but sitting down and putting our heads together with the Caring Society, with AFN and other parties, and hashing out a solution that is global in nature, doesn't re-traumatize children, and that actually fixes the system.
If there's 100,000 kids and the minimum is 40,000, if that's the floor, that's what the Human Rights Tribunal said, that's what the federal court upheld. Is the math 100,000 kids at minimum 40,000 or more? Is that the floor, $40,000?
We've said we are not interested in departing from a floor of 40,000 for removed children, but there are a lot of interwoven parts. There are children that are not caught by the order, that are caught in part by the class actions. We need to sit down with those parties and have those discussions so that everything is fair.
I get your intentions here. I'm not trying to cast aspersions, but is it an act of hubris that you think that the government in 60 days can solve a problem that the federal government has been fighting for 14 years? You've lost court orders, federal court, fighting and fighting and fighting. Now you lose again. You say, you know what we'll do? We'll solve it all in 2 months before the end of the year. Like, how do you propose to solve something that you haven't solved in 14 years in 8 weeks?
Look, it is a compressed timeline. It will no doubt be messy and emotions will run high, but we have the good faith and up to now the trust of the parties that this will move forward in a good way. Achieving long-term reform, getting a proper compensation package. Yes, it's ambitious, but we believe that we can achieve something, and perhaps even in the worst case scenario, winnow down an appeal that no one wants to the very minimum while being able to proceed in compensation for the children that have suffered harm. This is something that is important not only for us as a government, but for everyone in Canada and Indigenous peoples, and it's something that we've agreed to do with the parties. It is not something that would perhaps have been done in the past, and what we know over the course of 14 years is that there is a huge cost to inaction, and it's often been on the backs of Indigenous children.
You know, I've spoken, as you probably have, to Cindy Blackstock, who brought this case, who's been fighting for 14 years. On Friday, I spoke to her. She said, you know, she's just stunned that this appeal is going on. Pam Palmater, Mi'kmaq lawyer from Ryerson University. I'm going to play you a clip of her. She said she's so heartbroken to hear about this. I'm going to play you a clip of what she just said.
apparently we're going to court again. Kids, who are only have one lifetime. They have millions of nights away from their families, hoping that the government would make the right decision. When we hear ministers just this week saying this litigation is in no one's best interest and we have to work harder, this doesn't cut it.
So, Minister, just not a lot of trust there. This doesn't cut it. What would you say to Pam Palmater now?
Well, look, I have no reason to believe she would trust us, and in her position, as hard as I can't put myself in it, I wouldn't blame her. What we have said is we're going to sit down and do this the right way. We know that over the course of 14 years, there is a cost to inaction, and that cost continues. That is why we've made that undertaking for long-term reform.
Last question. What if you can't solve this 14-year-old legal dispute in an intensive 2 months? Then what? As I understand it, then it goes back to litigation. So the litigation's actually still hanging over this like a sword of Damocles. Is that right?
Well, the sword of Damocles is hanging over the Crown right now, and that's clear. What we know and what the Prime Minister has said is these children will be compensated. We are sitting down in order to find a global solution. I won't presume the outcome, and I don't presume to say that it's going to be easy. What we do know is we've made a significant offer on long-term reform, which is very appealing because this is a model that's broken and that we need to fix. The government since 2016 has made significant investments, but we need to make more. We recognize that, but we can't make it from on high in Ottawa. We need that work together with the parties, with the IFSD reports that have come up with financial models that are sober and appropriate, and we will work with Dr. Blackstock and all the advocacy that she brings to the table and knowledge to get this done in the right way.
Minister Miller, I really appreciate your time. Thank you, sir.
Thank you, Evan.